did someplace else.
I think if it was specifically a concern about the content, then that would trigger heightened scrutiny under the First Amendment. We're not trying to run away from that principle here. Instead, we're making, I think, a narrower argument.
Well, then I think that you're a little. I think you've just given your thing away because content manipulation is a content-based rationale. We think that this foreign government is going to manipulate content in a way that will. That concerns us and may very well affect our national security interests. Well, that's exactly what they thought about Communist Party speech in the 1950s, which was being scripted in large part by international organizations or directly by the Soviet Union.
I disagree that the concern with covert content manipulation is itself content-based or that it looks anything like the kinds of laws this court has previously said are content-based. The court, most recently in City of Austin, said you only have a content-based law when Congress is setting out to discriminate against particular subject matters or particular viewpoints. So it's not enough that the law is regulating in the space that involves content in some way. You have to have this motive by Congress to actually want to suppress speech on certain topics or certain viewpoints. Here, Congress just wants to cut the PRC out of the equation altogether, and all of the same speech could continue to happen on the platform. It's like patching up a backdoor vulnerability that the PRC has that we can't totally see around all the corners to imagine how it could use it against our interests, but we know the PRC will do whatever it can to try. And I think that is different in kind from imputing to Congress some motive to specifically get more speech on certain topics or with certain viewpoints. But this law was passed by broad bipartisan majorities in both houses of Congress, and our legislators and our legislators don't always agree on everything. I think it's unlikely that all of them had exactly the same views about what's good content on TikTok or what are good viewpoints. They weren't united on that. What they were united around was the idea that it is a grave threat to our nation if the PRC can itself behind the scenes be controlling how this platform operates.
Why doesn't this act classify on the basis of speaker?
I do think that when it comes to the PRC and ByteDance, you could treat this as a speaker-based restriction.
And aren't speaker-based restrictions almost always viewpoint-based restrictions, content-based restrictions?
The court has said it depends. It hasn't applied an inflexible rule that any time you are regulating certain speakers, you are invariably regulating based on content. And so the court has said it warrants closer consideration. And here, if you look at the US speakers, TikTok US and the users, none of them are being regulated in a way that suggests it's disagreement with their content. It's all about what our foreign adversary is doing.
And it's hard for me to think of situations, maybe they exist, where our classification based on speaker is not viewpoint or content-based restrictions. And that somebody says, Joe can't talk anymore. We're going to shut Joe up. And we don't know what he's going to say tomorrow or 2 weeks from now, and we don't know what he's going to discuss, but whatever he says is bad, because Joe is a bad person. I mean, that's viewpoint and content-based, isn't it?
I think when it comes to a foreign adversary, it's not right to view it that way. And the reason for that, again, is this is a sophisticated adversary nation, and we can't just simplistically say, oh, what the PRC is going to want is to see more pro-China content on this app. As Chief Judge Srinivasan observed, there are various ways that the PRC could try to create some kind of false flag operation and actually promote anti-China content, not to dictate how Americans should think about things, but simply to create some trumped-up justification for a military or economic action that the foreign
Hey, Olivia.
to take against us.
This is the live testimony from Supreme Court right now.
Viewpoint or content still. We don't know what the content's going to be, but we know Joe is bad.
Because I think the better classification is to recognize that what we're trying to prevent is not the specific subject matter.
Thank you for the tip, Olivia.
The technical capability of a foreign adversary nation to use a communications channel against this.
I guess I'm just struggling how covert content manipulation isn't content-based restriction.
So again, because
it's kind of hard to avoid the word content. And it's kind of hard to avoid the word viewpoint here, isn't it?
I don't dispute that it's related to content, but I don't think it reflects Congress seeking to set out in advance what kind of speech we should have reflecting certain views on certain topics. Instead, it's about trying to close off a vulnerability that our foreign adversary nation could exploit. And I would be remiss if I didn't point out that even if you thought this was content-based, all that means is that we're in strict scrutiny. And as the DC Circuit recognized here, we think that this law serves compelling national security concerns that sound in some of the same arguments I'm making here, and that have a long-standing correspondence to history and tradition of trying to prevent foreign control.
And then we get to the question whether there's at least less restrictive means. I get that, and whether disclosure might suffice. On the data security point, your friends on the other side make the argument that if that were the concern, Congress could ban TikTok US from sharing data with anyone, and on pains of penalties that would put people in prison and shut the company down in the future, as the government did, for example, with Arthur Andersen. Why isn't that a less restrictive means available?
So I was surprised to hear petitioner offer that up today, because there was a long course of discussion between the executive branch and ByteDance and TikTok leading up to Congress's enactment of this act that spanned over 4 years, an extensive conversation about what limitations could be placed to protect Americans' data. And it was never a suggestion that there would be any way to create a true firewall that would prevent the US subsidiary from sharing data with the corporate parent. And the reason for that sounds in the technological features of this application. I think there can be no reasonable dispute that the source code development and the maintenance of this algorithm rests in China, which is why China has sought to try to control export restrictions with respect to the algorithm. And what that means is you need substantial data flows between the companies in order to continue to modify that algorithm, refine it, and so forth. So I don't think that that was an option ever on the table, including with respect to the proposed national security agreement that was insufficient in protecting our data privacy and security concerns.
That didn't come across enough in the briefs. If we are in the world of data protection as opposed to content control, I think it's hard to get around the post-divestiture provision that says you can't do business with them on the algorithm, because that very much is content-based. It's a content-based restriction. But what you're saying is you can't do it for a data control reason, meaning that you can't really run their algorithm without sharing the very data that we are concerned about as a threat, correct?
That's right, Justice Sotomayor, and you don't have to take my word for it. You can look at
Olivia, I'm about to go to TikTok with this.
security agreement that ByteDance itself proposed. The relevant definition of the accepted